it is my pleasure to welcome you all today to this online discussion on the UN guidelines for lawyers in support of peaceful assemblies. This event is co-organized by the International Bar Association's Human Rights Institute, IBARI, by the Geneva Bar Association, the UN Special Rapporteur on Freedom of Assembly and Association, the Office of the High Commissioner for Human Rights, the United States Permanent Mission in Geneva, the International Commission of Jurists, and here the Geneva Human Rights Platform of the Geneva Academy. It is also co-sponsored by a number of organizations, notably the American Bar Association, Lawyers for Lawyers, Lawyers' Rights Watch Canada, Civicus, the Vance Center of the New York Bar Association, Media Defense, Robert F. Kennedy Human Rights, and the Law Society of England and Wales. I would like to thank all of our partners for their cooperation for this event. Now in opening, I do not want to go too much into the topic as we have a keynote speech, a substantive moderation, and obviously an excellent lineup of speakers for the topic today. Let me just say that for the Geneva Human Rights Platform, this is yet again an excellent opportunity to cooperate with a large number of partners to bring about this event, linking up diplomats, UN experts, academia, NGOs, and in particular representatives of the legal profession. Hosting also the Special Rapporteur on Freedom of Assembly and Association, as well as the representative of IBARI here at the Geneva Academy, I'm particularly pleased to see this cooperation taking shape. This year's edition of the Day of the Endangered Lawyer is dedicated to the situation in Colombia, so I am excited we have a colleague from this country also on the panel. Our event has, of course, also global reach, so in particular insofar as the promotion of the guidelines for lawyers in support to peaceful assemblies is concerned. The use of guidelines by human rights expert mechanisms such as the Special Rapporteur on Freedom of Association and Assembly is an increasingly used tool to combine an overview of legal principles to be observed by states with concrete advice to both states and also other stakeholders. In the given case, the pragmatic approach looking into the specific action to be taken by lawyers before, during, and after events is such an example. And practice examples from many states given in the document help also to contextualize those recommendations. And obviously also today is another UN day, it's the Day of Education. So I think it's also quite an educational material that was produced here by that UN mandate. It is my pleasure now to hand over the floor to the moderator of this event, Ms. Sandrine Giroux, who is president of the Human Rights Committee of the Geneva Bar Association, and I'm very much looking forward to a very interesting debate. Thank you very much, and over to you, Sandrine.
Thank you very much, Felix. Hi, everyone. Bonjour, bienvenue. It is a pleasure to welcome you to this event and to be your moderator for today. We have a fantastic list of experts, brilliant practitioners, people who really push the boundaries on this important topic. We will start with a keynote, followed by a panel discussion, and we will leave some time at the end for your questions and comments. It is important to remember that human rights defenders are really at the forefront of defending everyone's rights. It is often forgotten that lawyers after journalists are the ones most targeted from all these human rights defenders in danger. So lawyers are very much also at the forefront of all these battles, and they're often targeted because they are lawyers and because they're helping people implement and ask for their rights and for justice. And it is really important to keep in mind that without lawyers, you cannot have a meaningful access to justice. And so it is with this in mind that today we will celebrate the courage of our colleagues in Colombia, but also the important work of many of the people here and on the ground to defend the right to freedom, assembly, and association. And to start our discussion, I have the privilege to welcome Philip Riblet, who is the legal advisor at the US mission to the United Nations in Geneva, where he advises on legal issues relating to the Human Rights Council and international organizations in Geneva, including WHO, WIPO, and others. And since joining the office of the legal advisor at the US Department of State in 2011, he has covered an area of international issues in several offices, including the Office of Diplomatic Law and Litigation, the Office of East Asia and Pacific Affairs, and the Office of Legislation and Foreign Assistance. Before joining the Department of State from 2005 until 2011, Philip was an associate in a prominent New York private practice. And so he brings with him a wealth of experience on the field and on many fronts of international law. And we look forward to hearing from him and his take on the right of freedom of peaceful assemblies and association. So over to you, Philip.
Thank you, Sandrine, for that kind introduction, and greetings to everyone watching online. I was really encouraged to see the chat box with the messages from human rights lawyers that were logging in from different places around the world. I would like to thank the International Bar Association, Human Rights Institute, and the other organizers of this event for inviting me to make this keynote address. I have two objectives today. First, to share substantive observations that may help provoke thought and discussion by the panel. And second, to be mindful of the fact that the presenters who follow me have credentials that are more impressive than mine. So I'll be brief and then make way for the distinguished experts who follow me. The guidelines released by the Special Rapporteur provide a set of meaningful, practical principles and recommendations for lawyers working to promote the rights of peaceful assembly and of freedom of association. These guidelines are especially timely against the backdrop of peaceful protests in recent years on a range of issues, from racial injustice to elections. I'd like to set the stage for our discussion by asking you to join me in taking a step back and exploring why these guidelines are so important in the human rights landscape and our work here in Geneva. The guidelines can have a significant human rights impact due to the nature of the right of peaceful. These treaties constitute a cohesive whole, a range of protections to which individuals are entitled. What ultimately matters most is the implementation of those obligations by states. So we strive to identify ways to enhance that implementation. Respecting exercise of the right of peaceful assembly is a critical implementation enhancer. In other words, respect for the right of peaceful assembly promotes the protection of other human rights. Of course, individuals may engage in peaceful assembly for any number of reasons, but one purpose may be to protest what they view as a government's failure to uphold its human rights obligations. An individual with, for example, a right to the highest attainable standard of physical and mental health, or a right to form trade unions, might exercise the right of peaceful assembly and protest a government's policies if those rights are threatened. Peaceful protests can serve an accountability function, applying pressure on governments to change rights-violating behavior and thereby improving implementation by states of human rights obligations. Despite this crucial role, or indeed perhaps because of it, this right and others like it are under significant pressure in the world today. While the nature of peaceful assembly or association is that it involves multiple individuals, peaceful assembly is still a right that belongs to individuals. Individuals choose to associate with other individuals and assemble, but the right does not belong to the group. It belongs to the individual. It is a fundamental principle of human rights law that rights belong to the individual, and this is based upon the dignity that each of us has as an individual human being. That fundamental premise of human rights belonging to individuals is under threat, including here in Geneva. There are some who are presenting an alternative vision of human rights that is unrecognizable to human rights experts. In this alternative vision, the protection of individual human rights is subordinated to the government's promotion of social harmony and economic development for the country as a whole. The Human Rights Council is seen as a forum for promoting cooperation among governments and avoiding awkward conversations about things happening within the territory of a country. This alternative vision is, of course, antithetical to human rights, and the US mission spends a lot of our time pushing back against it. At any given time, the views expressed by individuals in a peaceful assembly will seem inconvenient, threatening, or simply annoying to some other individuals, often including individuals in the government. In a healthy society, individuals air their grievances and express their views. It is in our nature to communicate with others, to express our views, and to organize with others. Democracy is messy. People disagree. Society is not harmonious because all individuals have unique life experience shaping their views and what they expect from their government and their fellow human beings. A government that inappropriately constrains that expression fosters an unhealthy society. There's a reason why the allowable restrictions on peaceful assembly are narrow and specific in the International Covenant on Civil and Political Rights. It is the government's responsibility to preserve space for disagreement, and it is the lawyer's job to make sure the government preserves that space. Lawyers are the ones who help enable the exercise of the right of peaceful assembly, a right that, when exercised, enhances the implementation of other human rights. We're having this event today because it is the International Day of the Endangered Lawyer. There's a reason human rights lawyers are endangered, because they are making an impact that is inconvenient for people in positions of power. If the work human rights lawyers are doing did not have an impact, no one would care or be inconvenienced by it. We would all just carry on as we were. The fact that human rights lawyers are under threat itself demonstrates their effectiveness and the importance of their work. The Special Rapporteur has provided, based on widespread consultation, a set of useful, practical guidelines for lawyers defending the right of peaceful assembly. We will hear more about the guidelines during the panel discussion. In examining the guidelines, we should be sure to keep in mind why the work human rights lawyers do in defending peaceful assembly is so important to the protection of human. Thank you.
Thank you very much, Philip. I think you set the issue and the scene very well and very nicely, outlining the challenges and the importance of these issues. And so we'll be now hearing about experts and practitioners and activists who've been really trying to push the agenda on these important topics and to try to come up with solutions and guidance on how to really make the work of lawyers as impactful as possible. I will present each of the panelists now. They will then discuss their perspective, each one after the other, and then we'll have an interactive discussion because I think you only see the person speaking on the screen. I will introduce the panelists and just ask each of the panelists to say hi so that people can see your face before you start speaking. I will start with the incredible and very impressive Baroness Elena Kennedy. If you could just say hi, Elena. You need to unmute yourself and say hi so people can see you.
Hello, everyone. It's a great pleasure to be here. And Sandrine, particularly lovely to see you. The Geneva Bar Association has been a great supporter of many of these programs, bringing lawyers around the world together on important topics. And so I pay tribute to you and the Geneva Bar and to all of my colleagues who are on this panel. This is important. And I'm very privileged and honored to be here. I'm going to tell everyone in advance that I'm having to go to Parliament today, and so I won't be able to stay for the whole of the event, but I am very proud and privileged to be here to hear Clément and all of you, and I will look forward to hearing about the discussion.
Thank you very much, Elena. We know how important your work at Parliament is, and we were looking forward to hearing that. So for those of you who don't know you, you're one of Britain's most distinguished lawyers. You have spent your professional life giving voice to those who have least powers within the system, championing civil liberties and promoting human rights. You've conducted many prominent cases of terrorism, official secrets, and homicide. You're the founding force behind the establishment of the Bonavero Institute of Human Rights at the University of Oxford. And in 1997, you were elevated to the House of Lords, where you are a Labour peer. You've published a number of books, including 2 on how the justice system is failing women, and have written and broadcasted on many issues over the years. You're currently taking on the role of the director of the International Bar Association Human Rights Institute, which has been so active and so important in supporting lawyers. We've seen you recently on all fronts, from Afghanistan to recently also in the UK. You're really everywhere, really making sure everything is moving in the right direction. And we really look forward to hearing you. Thank you. I go on now to Clément Voule, a national of Togo and the UN Special Rapporteur on the rights to freedom of peaceful assembly and association. So Clément, if I could just ask you to say bonjour.
Bonjour, hi, Clément Voule, and nice to see you all. And thank you also for joining us this afternoon. And I hope we will have a wonderful discussion. Thank you very much.
Thank you, Clément. You've taken your functions as a UN Special Rapporteur in April 2018. Prior to your appointment, you led the International Service for Human Rights to support human rights defenders from states in transition, and you coordinated the organization's work in Africa as the advocacy director. You've been working tirelessly as a human rights advocate and defender in your native country, Togo, and across Africa. You hold a degree in fundamental rights from Nantes University in France and a master diploma in international in armed conflict from the Graduate Institute of International and Development Studies at the University of Geneva. So we really look forward to hearing you about your guidelines.
Thank you.
Next, Alejandro Lenz, who is a lawyer from the Universidad de los Andes and our representative for Colombia. So can you just say hi, Alejandro?
Hola para todas las personas, un gusto para mí estar acá con ustedes acompañándoles el día de hoy.
Thank you very much. Muchas gracias. You are currently the co-executive director of the organization Temblores, which is an NGO in Colombia. You worked in civil society organizations defending the human rights of LGBT people, sex workers, homeless people, drug users, victims of police profiling, and people deprived of liberty. During your career, you've built a strategic community litigation to defend the fundamental rights of sex workers and homeless people in Colombia. You also coordinated several reports on human rights of LGBTI people, homeless people, and sex workers. And you also created participatory and creative methodology for training of trainers for social change, which is a very important topic and also part of the guidelines. And so we'll really look forward to hearing you when you take on Colombia. And last but not least, we have Dennis Kwok, who is a founding member of the Civic Party in Hong Kong, now having to go to the US. Hi, Dennis.
Good morning, all. Good morning.
Yeah. So Dennis, as mentioned, formed in 2006 the Civic Party in Hong Kong. He was one of the key political parties in Hong Kong that championed the protection of the rule of law, greater democracy, and human rights. In 2012, you were elected as a member of the Legislative Council, representing the Hong Kong legal profession. The main policy areas that you have been focusing on included access to justice, human rights protection, and the independence of the judiciary in Hong Kong. You also served on the board of the China Human Rights Lawyers Concern Group, and you're currently a senior fellow at the Harvard Kennedy School and a distinguished scholar at the School of Foreign Service, Georgetown University. You've also been appointed a visiting associate professor at the University of Tokyo, and you're the recipient of the 2021 Commonwealth Law Conference Rule of Law Award bestowed by the Commonwealth Lawyers Association. Dennis, we're very privileged to have you, and you've experienced firsthand some of the challenges of accompanying and defending people who want to express their beliefs or their rights in peaceful assemblies, and with the consequences that might entail in difficult jurisdictions. So it will be really very enlightening to hear your experience. So to begin, I'll pass on the floor to Clément, who will present the guidelines and what led to these incredible useful guidelines for the role of lawyers in defending the right of freedom of peaceful assemblies and association. Clément, over to you.
Thank you very much, Sandrine, and I hope you can hear me now. It is a great pleasure to join this distinguished panel of colleagues and friends. Let me thank the Geneva Academy, IBARI, United Nations, the United States Permanent Mission in Geneva, and all the organizers of these events. In July last year, I presented to the Human Rights Council a set of guidelines on the role lawyers play in the promotion and protection of the rights to peaceful assembly. In this publication, I stress that lawyers and legal practitioners play a vital role in helping ensure access to justice for those exercising their right to peaceful assembly. Hundreds of thousands of people are killed, injured, and sexually assaulted every year as a result of unlawful and excessive use of force by law enforcement officials around the world. These acts remain largely in impunity. Authorities in many countries routinely ban and disperse assemblies and punish participants with harsh sanctions, including imprisonment. Internet shutdown and unlawful surveillance have become a frequent tools of repression of peaceful protest. And after the pandemic struck, a new wave of restriction to assembly rights and crackdown of dissent has emerged. The situation is arguably worse now for the majority of people in the world seeking to exercise their fundamental freedom. I believe that ensuring accountability and access to justice is critical in reversing these trends. A hindered access to justice in the context of peaceful protest not only infringes the rights of the victim, but has an overall chilling effect on society, discourages participation in assembly, and contributes to the dangerous trends of closing of civic space. Here is where lawyers and legal practitioners can help so much. Lawyers can intervene in support of the right to peaceful assembly at various stages. For example, they can support organizations and individuals' ability to comply with procedure required by law relative to the exercise of the right to freedom of peaceful assembly. They can work to ensure that individuals and groups are protected against violation and abuses. They can support effort to hold those responsible for rights violating to account and promote structural changes to reform the law, policy, and institutions that make this violation possible. The guidelines I presented address some of these areas of intervention with the aim of helping lawyers to better support peaceful protesters. These guidelines draw on the collective experience of legal practitioners from various jurisdictions around the world, many of whom have been forced to operate in restrictive, right-violating, and sometimes threatening environments. My goal in presenting the guideline was to offer a set of concrete practical recommendations oriented towards helping lawyers plan and prepare their work in the context of assemblies. For example, I recommend that the lawyers and legal practitioners first coordinate through organized network prior an assembly, provide training to protesters and assembly organizers on legal standards pertaining to the right to peaceful assembly, assists assembly organizers with any legal procedure or challenges necessary in the run-up to an assembly, consider the adoption of a code of conduct when observing assembly, This can help to ensure that all legal observers are on the same page, and appropriate action in the context of subsequent observation, and can also help clarify the function of the legal observers to external parties, but also and make themselves available to pursue legal avenue to support assembly in progress or after an assembly has ended, to ensure accountability and access to effective remedies when human rights violations are documented. I recognize that the ability of lawyers and legal practitioners to fulfill this role presupposes the existence of a fair, independent, prompt, and effective legal system. That is why, in the guideline, I emphasize that states have the primary responsibility to ensure that the right to freedom of peaceful assembly and access to justice are respected, protected, and fulfilled, including creating an enabled environment for lawyers to do their work. For example, states have the obligation to ensure that lawyers are able to observe, record, document, and report on assembly and measures taken in response. They must be able to provide legal assistance to all individuals detained, criminally charges in the context of assemblies. Lawyers must be free to carry out their professional duty independently and without improper interference from political actors of fear or reprisal. Without these safeguards, the contribution of lawyers in the promoting and protecting the right to peaceful assembly can be significantly hindered. So this is some of the elements that this guideline contains, and I look forward to our discussion, your ideas on what more we can do to advance new legal initiative in this area. So thank you very much for being here today, and I'm really looking forward to our exchange to see also how my mandate can continue to support the lawyers in this particular and critical area. Thank you, Sandrine.
Thank you, Clément, and thank you also for all the work behind these guidelines. I mean, it has been certainly an immense effort on your part, but also on all the people you've interviewed and you asked to try to really identify the issues and what could be done to try to address them. And now we'll be hearing from Alejandro Lenz as a lawyer, as a Colombian lawyer, also taking on very difficult cases and issues. So Alejandro, the floor is over to you on this important day dedicated to Colombian lawyers. Please let us know your experience and your take on these important guidelines and this important day for you and your fellow Colombian lawyers.
Bueno, muchísimas gracias por esta invitación y por este ajuste razonable de permitirme hablar en español. Los temas y los tecnicismos son tan profundos que me queda muchísimo más fácil poder expresarme en mi idioma. Entonces, para comenzar, pues me gustaría contarles un poco sobre lo que ha venido sucediendo en los últimos 3 años en Colombia a partir de un estallido social en el año 2019, en donde el país entero, nuestro país, fue testigo de cómo el Estado colombiano reprimió a la protesta pacífica y cómo a través de esa violencia perpetrada por los agentes de policía conocimos de primera mano cómo los agentes del Estado violentaban y asesinaban a los manifestantes pacíficos. El 23 de noviembre de ese año, 2 días después de que hubieran estallado las protestas sociales en el país, dieron la orden de dispersar la movilización pacífica. Y este suceso terminó con un homicidio que marcó la historia de nuestro país, que fue el homicidio de Dylan Cruz, un joven que había salido a protestar para reclamar educación pública gratuita. Después de este homicidio perpetrado por el Escuadrón Móvil Antidisturbios, una serie de grupos de abogados comenzamos a denunciar a través de acciones de tutela estas prácticas. Y hubo una orden judicial en la Corte Suprema de Justicia en la que se declaró probadamente que el ESMAD, es decir, el Escuadrón Móvil Antidisturbios, tenía una intención de no garantizar la vida y de proteger la integridad de los manifestantes, sino de atacar de manera muy violenta a la protesta pacífica. Uno de los primeros problemas con los que nos encontramos en la organización y con los que contamos los abogados que acompañamos y defendemos casos de protesta social pacífica es la falta de pruebas y la falta de una buena documentación de los casos. Por esta razón, nuestra organización creó una plataforma que se llama la plataforma Grita, que en español es gritar, hace alusión a eso, pero también quiere decir un acróstico, que quiere decir grabar, registrar, documentar, investigar y triangular todos los casos de violencia policial. Esta plataforma nos ha permitido que la ciudadanía clasifique su característica demográfica, es decir, la propia víctima puede decir si era una persona afrodescendiente, si era una persona LGBTI, si era una persona que pertenece a un grupo minoritario, y toda su clasificación demográfica, y también nos ha permitido que la víctima clasifique el tipo de actor agresor, si era una persona del escuadrón móvil antidisturbios, si era un policía, si era un miembro del ejército, o si era otro actor armado ilegal el que la violentó. En este último año, nuestra plataforma Grita, en el año 2021, duramos 3 meses de movilización social, una movilización que se tornó muy violenta y que sacó al ejército y a la policía a disparar directamente contra la ciudadanía. Nos permitió documentar en todo el año pasado 5.500 hechos de violencia policial. Esta información nosotros la entregamos a la Comisión Interamericana de Derechos Humanos y organismos internacionales de derechos humanos y permitieron de alguna manera que se diera la visita in situ de la Comisión Interamericana de Derechos Humanos en un momento muy crucial para nuestro país, en donde nuestra organización había documentado 80 homicidios, de los cuales 43 habían sido cometidos por miembros de la policía. Adicionalmente, nuestra organización creó una clínica de justicia ambulante, que es una clínica que le presta servicios gratuitos a la ciudadanía que quiere denunciar hechos de violencia policial. Muchas veces lo que sucede es que el video o la prueba o el documento termina en una nota de prensa o en un video viral en internet, y muy pocas veces se logra conectar a la persona que ha sido víctima con la administración de la justicia, y eso es lo que estadísticamente le permite al Estado mostrar que hay muy pocos casos de esta violencia policial contra manifestantes. Otro de los problemas con los que nos hemos encontrado es que existe una persecución muy grande por parte de agentes de la policía contra los abogados y contra las víctimas y familiares de quienes se atreven a denunciar violencia policial. En estos casos nosotros hemos documentado que solamente en los últimos 3 años, del año 2017, 2018 y 2019, nuestra organización tiene un registro de 289 homicidios cometidos por parte de la policía, de los cuales solamente la Fiscalía ha abierto 144 investigaciones y al día de hoy solamente ha habido 2 condenas. Esto es, en términos de porcentaje, que solamente el 2% de los casos en donde la policía está involucrada en un crimen de personas que salen a movilizarse pacíficamente, hay una condena efectiva. Solamente hay 2 condenas en lo que va llevado del tiempo. Es por estas razones que nuestra organización se ha preocupado muchísimo por fortalecer la documentación de los casos, fortalecer e invitar a la gente a denunciar los casos de violencia policial en el marco de la movilización social, pero también en dirigir una campaña nacional que permita abrir un debate sobre la reforma a nuestros cuerpos policiales al momento de salir a cuidar y a proteger la protesta social. Nosotros hemos insistido en que el año 2020, el año de la pandemia, fue la muerte del espacio público, y que parte de los retos más grandes que tenemos ahora como sociedades es recuperar el espacio público y reconstruir ese espacio público en las calles. El año pasado, las democracias estuvieron en las calles en nuestro país, estuvimos las personas saliendo a ejercer el derecho democrático a protestar pacíficamente contra el gobierno. Nuestra organización cumplió un rol de documentar y ser vedora de todos los procesos democráticos, y ahora nos encontramos promoviendo una discusión amplia nacional sobre una reforma estructural a nuestros cuerpos de policía. Una reforma donde los procedimientos policiales sean públicos y se cumpla con esta garantía constitucional, y en donde salga del Ministerio de Defensa, del Ministerio de Guerra, la Policía Nacional. Nosotros somos el único país latinoamericano en donde la policía aún permanece dentro del Ministerio de Defensa. Y esto hace parte del problema estructural en donde a la protesta social nuestra policía le da un tratamiento de guerra y una criminalización muy fuerte que se ha venido acentuando durante los últimos 3 años. Este último año tenemos un cambio de gobierno y una movilización muy grande en el país y esperamos que los ojos internacionales estén encima de Colombia para proteger y para ser veedores de los derechos humanos, como contribuyó mucho la comunidad internacional durante el estallido social del año 2021, en donde los organismos y parlamentos de distintos países fueron cruciales para que el gobierno negociara con los movilizantes y se redujera la violencia policial contra los manifestantes. El reto de aquí a 3 años es poder judicializar los casos que hemos documentado. Nuestras estadísticas propias registran unos hechos, alrededor de 5.000 hechos de violencia policial, pero solamente de esos 5.000 hechos hay 200 personas que quieren efectivamente llevar sus casos ante los procesos judiciales. Entonces ese es el reto al que nos venimos enfrentando desde hace ya 3 años y hacia el futuro también. Creo que ya se me está acabando el tiempo, entonces en la discusión podemos continuar con algunas otras cosas. Muchas gracias.
Thank you very much, Alejandro. I've noted down a couple of questions to ask you afterwards, so I'll look forward to our discussion. So, Elena, you've also been mentioning your important work now in the UK, where freedom of assembly or peaceful assembly is also under attack, like we've seen in many of our jurisdictions, the debate over COVID, vaccine, not vaccine. I mean, there has been so many protests, people expressing different opinions. Close here, but also on many other topics, and you see the situation being increasingly tense with attack on these very important rights. So what is your take on it?
Let me start, Sandrine, by saying that first of all, I want to pay a tribute to Clément Voule for his reports, 2 reports, really wonderful reports that he's produced in recent times. One is on access to justice as an integral element of the protection of rights of freedom of assembly and association, because we know that rights are meaningless unless you can actually have lawyers to help you make your case and to protect you when you appear before courts. And lawyers often in the end feel intimidated about doing that. We've just had the whole experience in Belarus of lawyers themselves who've acted for those who participated in the demonstrations against the horrible clampdown on the opposition by Lukashenko, who's really a dictator. That many of the lawyers have been struck off, they're not able to practice law, and others were arrested and indeed didn't have experienced sentences to long imprisonment. So we know these terrible things are happening, and so therefore Clément's reports, not just on access to justice, but on these new guidelines are really important. I just wanted to start by saying to everybody that independent lawyers are fundamental to the rule of law. You know, we often talk about the vital thing, the rule of law. What does it mean? That we have to have independent judges to make decisions separate from the politicians. But in amongst all of that, sometimes is lost the fact that independent lawyers are also fundamental to the rule of law, and the rule of law being fundamental and a pillar of a democratic society. And so I want to remind people that there are UN basic principles on the role of the lawyer, about why a lawyer has to be protected. And we chose today, which is the Day of the Endangered Lawyer, for this gathering, because the role of lawyers, we have to keep reminding governments of how important lawyers are in maintaining the system. And unfortunately, in too many places, people can't afford lawyers. Lawyers are not surprisingly given a bad rap in the press because they are assumed to be there for the money, whereas many of us have become lawyers as part of a vocation, because we want to be acting for people, to make our societies work better, to make sure that people get their rights. And we shouldn't ever be embarrassed about that principled role that we as lawyers play. Now, I wanted to remind everybody, let's not forget the romance and the importance of the stories that we have to tell the general public about why the freedom of assembly, freedom of expression, the right to protest, the right to association with others who might share your views, that is vital to a democracy, as our keynote speaker said. But let's remember what it produced. It produced women's votes. Many people it's really been in the history of humanity, it's been in comparatively recent times that the right for people to choose those who are their governors and who lead them and who in parliaments make laws, that was secured by people taking to the streets. And so the right to protest got women the vote, the right to protest, let's not forget Martin Luther King, let's not forget Gandhi. The whole business of protesting has secured huge advances in our societies, workers' rights, LGBTI rights, struggles against racism. All those struggles to make our societies better have been produced almost invariably by protest. And the reason why? Because people who have power do not voluntarily give it away. And so we have to remind people why protest matters. And some of the things that we have to do as lawyers is make the case for this, because it's so important. I want to just remind everybody who's listening of a really important case. It was a case that was decided in front of the Inter-American Court of Human Rights in 2015, a case called Lopez, Lone, and others versus Honduras. And the Inter-American Court of Human Rights made a very important decision. They said the case was about judges all being sacked because judges had spoken out about a coup that had taken place in Honduras, and the removal of all the normal democratic protections that citizens have. And so the court judges were sacked. They were disciplined and then sacked. And the court concluded that at times of grave democratic crises, judges should speak out and act in defense of the democratic order, not only because it is in their rights as citizens to legitimately exercise their own right and their own rights for freedom of assembly and freedom of association, but because they are also the guardians of justice. And when we think about what's happening around the world, and we think about Belarus, but we also think about Hong Kong, and Dennis will speak about all of that, Chile, Nicaragua, Colombia, which is sitting at the center of today's Day of the Endangered Lawyer, when so many lawyers have suffered. But many places around the world, including in advanced democracies. My own society just now is passing law in the United Kingdom, passing law which is to greatly inhibit protest. And they are seeking to criminalize people for protesting. And they wanted to create orders that would prevent people who went on more than one demonstration, to prevent them actually exercising their right to protest. They want to put it all in the hands of politicians deciding who gets to protest and who doesn't, so that there can be banning orders. They don't want it to be in busy thoroughfares. Well, where else do you want to take your protest if not into the center of cities and to the places where parliaments and assemblies are? They want to have stop and search of people going to demonstrations, so that if you're there with a banner, they want to be able to stop and search you automatically without good cause, just because you're simply going there carrying a banner. They want to prevent demonstrations on the basis of noise or disturbance of anybody. Well, international law makes it very clear that, of course, there's going to be there has to be a tolerance of disturbance and of noise. So even I'm giving you an example of the law that they're trying to pass in the UK at the moment, and it's a shocking example of the ways in which governments, even in developed democracies where you would expect better, seek to prevent protests. Now, I wanted just before I depart to make a number of pleas to people. I want to say that we, IBARI has been at the heart of creating today's event. That's the International Bar Association's Human Rights Institute, of which I'm the director. We want to play a role in upholding freedom of assembly, and we want to continue to support the Special Rapporteur. Clément is a wonderful leader for us, and he's done the most incredible work, but we have to realize it by being advocates for his work. The International Bar Association is a global voice of the legal profession worldwide, and we're going to continue to promote the guidelines amongst lawyers and legal professionals, including lawyers who are not necessarily the lawyers who take these issues up normally. We've got to get commercial lawyers and other lawyers feeling that this matters in a democracy, and that they're not going to be able to do their role in advancing, commercial interests and economy and so on, if they don't have this existing tool. Vibrant democracies need this, and they should be also volunteering to be monitors of demonstrations, putting on your high-vis jacket that says on it, legal monitor or legal presence or something, in the way that the press are protected and that you can actually record and bear witness to what's happening and monitor what's going on and be an intermediary with the police. But also in advance of some of the big demonstrations that we had against the Iraq war, that we had around the world in relation to different climate change and so on. These are vital issues affecting communities everywhere, and people have to be able to protest, and we should be involved in pre-organizing of those things, and people should be taking legal advice and reminding people of why they matter, and then in turn being present on the streets, bearing witness to what happens, and using the apps which now exist. Eyewitness, an organization associated with the IBA, has an app where you can actually film things that you see which are abuses by the police at protests, and which can then be kept on an archive for later use in courts. The lawyers and the legal profession can play a key role in all of this, and we want to support the Special Rapporteur in the creation of a legal network of lawyers, and so that they know the roles that they can play. And we would also like there to be user-friendly version of the guidelines that could be used so that we can present them to the general public. And we also think that there might be opportunities for training in all of this. So I just wanted to add our voice in saying this is so important. And I'm so glad that Dennis is going to come after me, because he's going to speak about all of this. And Dennis, I hope you'll use that case in reminding judges in Hong Kong and judges from other Commonwealth countries that go out and sit on that Supreme Court and sit in judgment in those cases, and therefore perhaps providing a sort of cosmetic front on things that are happening about the rule of law in Hong Kong and in other places. But I really do think that we should be reminding judges that they have a role in protecting democracy, and that they should not be intimidated into collusion with governments that are trying to prevent fair protest and peaceful protest. So it's no wonder that protesters become angry and then behave in ways that bring clamped down. It's because often the police behave so badly, and we've had it with a thing called kettling in Britain, where they would push people into tight, constrained areas, and it was a way in which then people couldn't go to the lavatory, they couldn't, and they'd be kept there for hours on end, unable to move. And it was basically to put them off ever wanting to take part in a protest again. So I do want to say to everyone, this is a fundamental for democratic societies, and we have to protect each other and each other's countries when things go badly wrong and protest is being suffocated and stifled. Thank you very much, all of you. It's wonderful to be in your company, and I know that we together can make the change. Thank you.
Thank you so much, Helena, for your very powerful speech and reminding all of us that far away or close to us, the fight has to take place, and we have to remain vigilant. I mean, you've addressed all the important changes in our society. I mean, no one can escape the pandemic. No one can escape climate change. There are tension in many government of transition or countries where social tension is rife. So as you say, we need to have a forum where people can express themselves and those rights be protected. Thank you so much, Helena. And well, if you have to go, please go, but it's a privilege as always to have you, and all the best for you fight in the UK. You're still on mute.
I send my regards to everyone who's spoken today, has spoken powerfully. I want to say to Alessandro how much I admire his courage and the courage of his colleagues. And I know that you've been going through many years of hard times, and we stand in solidarity with you. And to Dennis, my great colleague and friend, and I have many friends in Hong Kong, and like Dennis, they've been incredibly courageous in speaking out about what's happening. And I fear for our colleagues there. I send you my support as well, because these are not good times for Hong Kong. Bless you. Thank you.
Thank you, Helena. So Dennis, well, all these very powerful and thoughtful words from Helena, do you want to share with us your own experience?
Well, absolutely. And I just want to echo everything Helena said, and also especially her praise for Clément's work as Special Rapporteur, and for Alejandro, your courage and your circumstances. And I just want to tell you, you're not alone. I just want to speak a few words about the situation in Hong Kong. As many of you know, that Hong Kong used to be one of the most vibrant civil societies in the Asia Pacific region, with international and local civil society groups actively raising civil rights and human rights issues for many decades. Now, in a little more than just a year, all that has been completely and utterly dismantled by the authorities under the disguise of the national security law that has been imposed by the National People's Congress in Beijing directly on Hong Kong in June 2020. Since the implementation of that law, the National Security Police have arrested, prosecuted, investigated more than 20 to 30 civil society groups, forcing many of them to leave Hong Kong or to close their operation. And those leading some of these civil society groups are now currently in jail for their involvement. In particular, I would like to mention a few lawyers, human rights lawyers in Hong Kong that are currently in jail. And I think they deserve our attention and for the work they have done. The first case I would like to raise is Ms. Chow Hang Tung. She is a 36-year-old barrister, educated in Cambridge, and has been the vice chairwoman of the now disbanded Hong Kong Alliance in support of patriotic democratic movements in China. The Hong Kong Alliance has been organizing candle vigil, peaceful assembly of the commemoration of the Tiananmen Square massacre. You remember images of tens of thousands of Hong Kong people coming to Victoria Park, holding the candle every year on the 4th of June to commemorate what happened in Tiananmen Square. It has always been a peaceful and well-attended assembly. Now, in the past 2 years, the Hong Kong government has banned that assembly on the grounds of COVID. And not only that, they have prosecuted and brought about convictions of many organizers and many people who attended these peaceful assembly on the grounds that they were unauthorized. And very sadly, the Hong Kong courts, who are meant to be the defenders and protectors of human rights are now a willing accomplice to this regime in suppressing human rights and sentencing people like Ms. Chow to 15 months in jail simply for organizing or so-called inciting a unauthorized but peaceful assembly of people who are there to commemorate the Tiananmen Square massacre, which used to be a symbol, the beacon of light for Hong Kong, is now completely snuffed out. And people like Ms. Chow, who is a lawyer herself, is now in jail for 15 months or possibly more. She has a few more charges that are currently brought against her. I just want to raise her case because I think she's one of the finest examples of lawyers not only defending human rights in the courtroom, but also lawyers who are out there on the front line in civil society, who are on the front line of the assembly, organizing, advising, and protecting the human rights of herself and others in peaceful assembly. And people like her are now being targeted by the Hong Kong authorities. And I would call on the International Bar Association and also bar associations around the world to monitor her case very closely. I don't know whether they would do further things to her in terms of her license to practice, etc. But I think on this day, people like her should be remembered. And also, there's another lawyer and a very close friend of mine who is also in jail. His name is Albert Ho. And he and I used to serve together on the China Human Rights Lawyers Concern Group. Now, the thing about Hong Kong is that we don't only organize civil society that is focused on what's happening in Hong Kong, but we also help those in China, our colleagues in China, the human rights lawyers in China. We used to have a group that support them, provides a network of support for these lawyers. Now that group has now been disbanded because it's been investigated by the National Security Police, calling them a foreign agent because they may have, like many civil society groups, accepted funding from international civil society groups and NGOs for their work over the years. And the National Security Police is now saying, oh, you are a foreign agent and we are investigating you. And the offense carry a maximum sentence of life imprisonment if you act in collusion with foreign elements, and is a very vaguely drafted law. Albert Ho is now in jail as well. He has been serving the legal profession in Hong Kong for the past 4 decades, and he has been sentenced to jail for attending and organizing an unauthorized peaceful assembly. Again, something that the courts in Hong Kong seems to be turning a blind eye to the basic human rights of the defendants, and just going along with the regime imposing heavier and heavier sentences on the defendants that I've mentioned. And a lot of people ask me whether the courts in Hong Kong are still independent. I would say the institutional independence of the Hong Kong judiciary is now gone. And the reason I say that is because through the interpretation of the basic law, notably Article 104, the National People's Congress Standing Committee can now exercise the power to summarily dismiss any public officers, including judges who are occupying public office, summarily dismiss them on grounds that they've breached their oath. And they could be removed without protection, without due process, and that they're, after removal, they could also ask you to pay back your salaries, and you could end up losing your pension. So, you know, for anyone who argue that with such a system in place, the judges know it, and before every important case, the pro-China media will almost pronounce the judgment that they would like to see in a particular case, and almost threaten the Hong Kong courts to say that if you don't come up with the result that we expect to see, well, let's see what will happen, you know, like basically a threat to the Hong Kong courts. And with that system in place, I don't think anyone could argue that the Hong Kong courts are still institutionally independent. And I'm very saddened by the statement that's been issued by the UK Supreme Court to say that they still have confidence that the Hong Kong courts that currently in place are still independent. I don't know what they're basing that finding on. And I echo the remarks of Helena just now regarding the situation of judges serving in Hong Kong. This is all happening as we speak. And I just wanted to use this occasion to remember the colleagues that I have fought together with in many years and decades. And the fact that I'm free, but they are in jail is very sad, but also I think their bravery and their courage deserves our utmost respect and attention. I'm happy to answer any questions you have regarding the situation in Hong Kong and also the related events in China. So thank you very much for organizing and allowing us to remember our colleagues on this very important day.
Thank you very much, Dennis. Thank you for remembering all those very brave and courageous people and colleagues. And thank you also for your own courage for speaking out, because it also comes at a risk for making sure that those who cannot speak now have a voice and to speak out against these many violations. I'd like now to open the discussion among the panel before taking some questions from the audience. There was one important point I wanted to ask Clément about, and it was also in relation to something you said, Dennis. It's the principle of non-interference and impartiality you mentioned, Clément, in your report, and also the importance of observation, that simply being present at a peaceful protest and observing is a vital role in reporting and documenting what's happening and then helping enforce rights of those who protest. But in my experience, there has been also a tendency to attack lawyers who were present at those protests, saying that they were part of the protest, that they helped organize these events. As you mentioned, Dennis, I mean, some of your colleagues had did not only provide legal aid, but they were also part of the protest. And as the Geneva Bar has a system to support lawyers in danger, where we reach out to them and we try to raise awareness as to their situation. And we help lawyers who are acting in their mandate as lawyers. But we have sometimes come under criticism for having helped people who are allegedly not acting as lawyers, because organizing a protest is, for some people, not acting as a lawyer. And we had that discussion with the Special Rapporteur on the independence of judges and lawyers, and he made it clear that no, it is part also of a lawyer's job sometimes to participate and to help organize this event. So just to avoid any ambiguity about this possible dual role, could you, Clément, clarify what you mean by the principle of impartiality and non-interference?
Thank you very much, Sandrine, for this question. And I'm also happy for others to bring their own experience on the ground. But what I hear from lawyers and during this process is also that one of the challenges that peaceful protests face whenever they have access to justice is also sometimes the question of evidence. And as you know, the independent observation from lawyers provide evidence during the judicial process. And we know that this is always what many governments will use because police will use their own recording that they have. And as you know, when during the judicial process also, is also the voice of the victim against the voice of police. And that's why the impartial and independent lawyer being able to observe and also provide evidence during the process that this is what happened is also important. And because the lawyers also are in front line, they are the one also that will defend the protesters that are arrested. And they have also, for them observing this and providing evidence is also a way also to be able also to have a judicial process that is fair, that is also based on actually independent view and also independent collection of evidence. And I think this is the point that I made there, trying to talk about the need also to have this kind of code of conduct among lawyers on how to observe that, because it's important how we record those evidence and to ensure also that during this process because I have during the process of drafting this guideline, I have also many lawyers coming from different parts, from France, helping also Gilets jaunes, coming also to talk about this lack of evidence, or police having their own evidence, but also participants saying this is what happened. But at the same time also, you see, you are it's police against the victim, and you don't have an independent voice, an independent evidence that will show what happened really. And I think also for me, the presence of lawyers during this observation also, it also have preventive measure. And in most of the cases, we know that when lawyers are there, when police know that they're observer, police is more reluctant on using certain force, using excessive force, or sometimes going beyond what is their normal duty or what is required by the law. And it's also important when I'm talking about improper interference, I'm also talking about being able to leave lawyer to do his job, as an independent lawyer doing his job, and being able to be able to record the evidence and to be able also to provide those evidence during the court procedure, so that the judge have the possibility also to hear victim, to hear also the observer, those who provide this evidence, and also to hear also law enforcement. And I think this for me is a key sometimes to try also to kind of ensure that judicial process is not, it is not against most of the time the victim, participant, but also it provides also evidence where law enforcement can be also held accountable. And most of the time, the reason why law enforcement doesn't want that, because they don't want to be held accountable. And the problem is sometimes, what are the evidence? And when people are protesting, they don't have time necessarily to record what is happening. They don't have time also to look at what is going around, what police is doing, how the police also is behavior. And sometimes from my experience and from what I hear from the law and from what I hear from some monitor, police sometimes doesn't want to have people that are observing the way that they are operating on the ground. And this is what we say, you need to change. You need to change,
Thank you. I think that's really an important point, that the observation part of it. Do we agree as well that a lawyer that would help organize and in fact exercise the right to freedom of assembly, in fact, is also exercising and defending its rights? So as a lawyer, he should also be protected in that capacity.
Yes, I fully, I think my mandate already, we mentioned this for many times, that participants and observer are protected under the exercise of the principle of exercising of the right to peaceful assembly. Those who are observing, those who are participating, they are all protected. And this, the right to observer also to be identified, one of the facts, I think this principle for me is quite important, that lawyers being there, lawyers is also protected as a participant. In addition to that, what we are trying also to push is that the police and the state need to recognize that lawyers, they have this additional lay in terms of observing, in terms of also police facilitating their observation rights, because it's important. And from the evidence that we receive, that whenever we have, because one of the questions that always the police put in place, today we have all the cameras, CCTV around, but whenever we go to the courts, one of the things that the courts always, or police show, is where participants may become violent, but without saying why the participant sometimes react as this. So those are things that sometimes is missing. And for me, is that lawyers are protected, like you asked, they are protected as a participant. They have the right to life, they have the right to the right also to observe, the right also to not be tortured, to not be arrested. They have all of these rights.
Thank you very much. And someone has mentioned in the blog Article 23 of the basic principle on the role of lawyers that reminds everyone that lawyers are entitled to freedom of expression, belief, association, and assembly. So it goes exactly to your point. I'd like to go back to Alejandro because there are a couple of questions that are addressed to you. First, my question is on this particular day of the endangered lawyer, how important is it to make Colombia the focus of today's attention? Is it helpful? And what could be done more to help Colombian colleagues in their tasks?
Bueno, también tenemos, como contaba un poco Denise, una nueva ley de seguridad ciudadana en Colombia que salió. En Colombia existe la costumbre de publicar leyes y sacar leyes muy complejas, inconstitucionales, que la gente no se puede objetar, ni la prensa puede estar muy pendiente. Entonces, este tipo de prácticas en Colombia son muy usuales. La ley salió el 28 de diciembre, cuando las personas estaban en vacaciones, en los últimos momentos donde hay muy poca prensa. Las organizaciones de la sociedad civil tienen pues mucha más reducción de sus miradas y sus ojos sobre los procesos legislativos. Y esta ley es una ley de seguridad ciudadana que tiene una serie de problemas muy graves en términos de protesta social y de clasificación de una serie de conductas que ponen en riesgo la seguridad ciudadana. Y este tipo de conductas son conductas que están protegidas constitucionalmente, son conductas que están relacionadas con la protesta pacífica y con la protesta social. Se prohíbe de una manera mucho más tajante la utilización de capuchas que permiten a las personas salir a la protesta social y no ser identificadas, que son estas gorras y capas que es muy usual que muchas personas salgan así para evitar ser criminalizadas posteriormente por participar en protestas. Y toda una serie de figuras como los centros de traslados por protección. Es una figura que tenemos en Colombia en donde la policía puede determinar que si tú estás en un grado de exaltación o de excitación, pueden llevarte por 12 horas a protegerte tras las rejas. Esta es una figura muy compleja porque es una figura que no tiene control judicial, porque no hay un juez en un momento que pueda controlar la figura, no existe ese control judicial. Entonces puede ser utilizada varias veces contra una misma persona, contra personas que están en el espacio público, con la sola discreción de que un policía considere que tú estás en un grado de excitación o de exaltación. Y esta es una de las figuras que más se utiliza en la protesta social para cargarse y llevarse en los camiones a la gente que está protestando. Tuvimos alrededor de 4.000 registros de esta figura utilizada. Y además, esta es una de las figuras que termina convirtiéndose es el primer paso para poder, digamos, después ejercer actos de violencia sexual, violencia física. Cuando la persona entra en custodia de la policía, es el momento dentro de los camiones y dentro de ese traslado y ese trasteo donde son agredidas las personas. Y en ese rol lo que ha sucedido es que la policía le ha impedido a las personas comunicarse con un abogado o abogada, no les han permitido realizar ni siquiera la llamada, y es lo que nosotros hemos nombrado como una captura con fines de ocultamiento, que en algunos casos puede configurar desaparición forzada, porque hay un interés de la policía de ocultar a los abogados y a las personas que esta persona está siendo llevada a una guarnición militar. Es por esta razón que muchas personas que eran capturadas en el paro del año pasado gritaban su nombre y su número de cédula de una manera un poco muy angustiada para que la gente registrara este nombre, y tuvimos alrededor de 700 personas que denunciaron desaparición forzada, que la gran mayoría de ellas vivieron violencia policial, pero que en la angustia del grito, al momento de entrar en las patrullas donde se capturaban, pues gritaban sus números de cédula y sus nombres para que por lo menos algún registro de las personas que acompañan y documentan todo el proceso desde la profesión de ser abogados, pues pudieran después ir a las estaciones militares a averiguar por estas personas. Pero esa es como la primera pregunta. No sé si la otra la quieras decir de una vez o después en otra ronda.
There's a second question to you as well, if you can address it quickly, which is the reporting mechanism for abuses by the police in Colombia, whether it covers all contexts of police-public interaction or just public assemblies.
Bueno, pues parte de los problemas que existen y que tenemos en Colombia es que no hay unos mecanismos transparentes y claros del actuar policial. Y en el caso de que existan, en muchos de los casos, es muy difícil de acceder a ellos. Otro de los grandes problemas con los que estamos contando ahorita es este derecho de petición a la información. Nosotros teníamos una figura muy importante en donde cualquier autoridad tenía que contestarnos en 15 días hábiles. Y si no nos contestaba, podíamos ponerles una acción de tutela para que un juez obligara o a la fiscalía o a la policía a contestar esa información. Y como consecuencia de la pandemia llevamos un año y medio, ya vamos a cumplir un año y medio, en donde el plazo de respuesta se duplicó y las instituciones no nos están contestando información estatal, y todo este sistema de rastreo de casos y de datos se demora más del doble o el triple hoy en día. Entonces hay un problema muy grave en el tema de acceso a información pública del Estado, que cada vez se ha venido profundizando más en Colombia.
Thank you, Alejandro. Just a last question, and then I'll open the floor. The guidelines as such, are they useful to you? To what extent can they help in your work on the ground?
Sí, las directrices, pues para nosotros es muy importante estos mecanismos internacionales y este tipo de directrices y de consejos que dan los organismos internacionales para el Estado, sobre todo para las organizaciones de la sociedad civil y para los jueces. Nosotros utilizamos todas estas recomendaciones y directrices en todos los procesos judiciales. Parte del trabajo que hacemos nosotros en la organización es litigar y hacer litigios estratégicos para que estas directrices queden vinculadas dentro de decisiones judiciales en la Corte Constitucional y en la Corte Suprema de Justicia. Y es la forma en que nosotros tratamos de hacer el activismo judicial de esa manera. Para mí, sinceramente, en el otro plano, en el tema del Ejecutivo, para el gobierno y para el Estado colombiano y para la historia de nuestro poder ejecutivo han sido muy poco efectivas, pero para todo el Poder Judicial y para todos los tribunales y para las Cortes es como el lugar donde nosotros podemos utilizar este tipo de recomendaciones y directrices para generar una transformación y unas líneas de trabajo que se ciñan a ellas.
Thank you very much. I've noted a couple of comments and questions and people who would like to make interventions. I noted in particular Tas Liveris and also Civicus. I don't know if we can, I'm asking the technical support whether they can just speak out or if we need to upgrade them for them. Yeah, I see Tas Liveris. I think you can just unmute yourself and yeah, okay, welcome. You can go ahead.
Thank you, Sandrine. On behalf of the Law Council, can I quickly commend the Special Rapporteur for producing these important guidelines and thank everyone who's contributed to their development, and also the co-organisers and co-sponsors for facilitating this valuable discussion. As the Special Rapporteur noted, although the guidelines set out fundamental principles, we see local conditions necessitating differences in implementation and approach, and we see three major ways that bars and law societies can play a role to implement and promote these guidelines. Firstly, as a representative voice of the local or national legal profession, which will advocate for lawyers to be able to conduct their professional duties without intimidation or reprisals. Secondly, as a source of independent expert legal comment that will assist lawyers. It will build capability and knowledge and it will also provide community legal education. And finally, they may also act as an interface between lawyers and the executive, importantly advising governments on legal frameworks which support the exercise of the rights to peaceful assembly and accord with the state's international human rights obligations. But whatever role bars and law societies play, and however they can contribute, I hope that we will all support and stand with our international colleagues working to facilitate and defend the right to freedom of peaceful assembly and association. And here in Australia, the Law Council of Australia remains committed in that regard. Thank you.
Thank you very much, Tas. And I think we also have a statement or a comment from Civicus. Nicola?
Thank you, colleagues. Can you hear me?
Yes.
Thank you. Thank you for convening such an important event and for very inspiring presentations. This event is particularly pertinent the year after the publication of the Human Rights Committee's General Comment 37 on freedom of peaceful assembly. Access to justice remains one of the greatest challenges for peaceful protesters, not only in more authoritarian states like Belarus, Cambodia, and Venezuela. Increasingly, in established democracies such as in the UK, France, and in the US, Civicus has indeed documented that protesters are unlawfully detained or met with police violence, and often with impunity. Protesting is an essential component of governance. It is inconceivable that people should have to risk their freedom and sometimes their lives to attend a peaceful protest. The General Comment is very clear on states' responsibility with regards to accountability. The Special Rapporteur's guidelines set out some really practical and helpful best practices for lawyers to support the implementation of the General Comment. It includes a number of inspiring examples of lawyers or networks of lawyers coordinating in support of peaceful protests. Again and again, we and our partners have seen that the very presence of legal monitors has deterred authorities from excessive use of force and from making arbitrary arrests. It is important to note that legal monitors themselves can face the same risks, especially in the midst of monitoring a protest, as those whose rights they protect. For the lawyers in the room, it would be great to hear more from you about what could make you feel safer, what these and other challenges lawyers face in protecting freedom of peaceful assembly can be best addressed at the international level. As a final point, even before the protest starts, we have seen an increase in restrictive laws across the world which curtail freedom of peaceful assembly. Lawyers not only have an important role in protecting peaceful assembly as it happens, but also in challenging restrictive laws which threaten this fundamental freedom. Thank you.
Thank you very much. I see a couple of more comments and questions. So I see that someone from the Association for the Prevention of Torture, Valentina Cadero, who wanted to leave her thoughts on the chat. Otherwise, maybe we can upgrade her so she can take the word. And while we do so, I just wanted to go back to what something Tas mentioned, but also Clément and Dennis, is to the importance of bar association. And it is really, as you say, of utmost importance that bar association raise awareness. Well, first are conscious of these issues, then raise awareness, and then train their members on these important topics, and remains in solidarity with colleagues all over the world who are targeted because they are fighting for those rights. So I would need to commend all the Bar Association who supported this event, but who support many other actions throughout the year. And so that, I think, is really also one takeaway from this webinar, is that as lawyers, it is also for us to then go back to our bar and try to make things happen. And I think that's also one of the questions raised by a colleague from the American Bar Association to Dennis. What role can International Bar Association play to support, in this case, particularly Hong Kong lawyers, but I guess more broadly, any lawyers targeted when fighting for the freedom of peaceful association?
Yeah, thank you for that question. When we were in Hong Kong, we used to set up groups like the China Human Rights Lawyers Concern Group to support our colleagues in mainland China who are fighting the good fight and defending people and getting disbarred from practice. They get jailed, their families are threatened. Unfortunately, I think the Hong Kong bar and the lawyers who are willing to take up these human rights cases in Hong Kong or these political prosecutions are under severe pressure these days. And I can only imagine how hard it is becoming for them to take up these cases at the cost of their own career development, because it is becoming a society in Hong Kong where, if you stand on and defend these people and you are marked out as a quote and unquote liberal thinking lawyer who speak out and defend these defendants, you'll be marked out as one of them, and it will be detrimental to your legal career. It will be more difficult for you to develop other clients. And so these people are really doing it because they believe that it is the right thing to do, and it comes at a great cost to themselves. And I think that colleagues around the world need to realize these circumstances, and the International Bar Association, also bar associations around the world, really should monitor these cases. As I've mentioned, the case of Ms. Chow and also Albert Ho, for example, these are examples of human rights lawyers being jailed for what they do. And unfortunately, that's happening in Hong Kong now. And what is the International Bar Association going to do to support these individuals, especially if at some point the authorities take action against them or threaten to take away their license to practice? And this is precisely the kind of issues that the IBA need to take up. And I would call on also Clément's office to raise these issues in their report.
Thank you very much, Dennis, and thank you to Terence for his question. Now, just a last statement, maybe from Valentina. So if you can unmute yourself.
Yes, thank you very much, and I won't take too much time. So greetings from the Association of the Prevention of Torture. I first of all just like to express on behalf of the APT our warm congratulations for the development of these new guidelines. And I also like just to share a few reflections on behalf of APT. First of all, we wanted to encourage the use of these new guidelines by lawyers in strict cooperation with national human rights institutions and national preventive mechanisms, and any other relevant stakeholders who monitor assemblies. At the APT, indeed, we were able to observe an emerging practice by oversight bodies to monitor assemblies. This has been the case, for instance, in Austria, Chile, Spain, Uruguay, and Tunisia most recently. And this also has resulted in close cooperation with lawyers. And we think that this cooperation indeed should be further encouraged in the future. Second, we wanted to note that these new guidelines constitute a particularly welcome step towards strengthening the preventive role of lawyers to ensure respect for human rights, including the freedom from torture and ill treatment in the exercise of the right to peaceful assembly. And related to that, and from a prevention perspective, the APT also encouraged the integration of an assessment of vulnerabilities in the use and implementation of these guidelines in the future, as these indeed can play a crucial role in enhancing also the monitoring activities by lawyers by allowing them, for instance, to pay particular attention to specific groups or persons at risk. And finally, we just quickly wanted to note that the new guidelines also perfectly complement the recently released principles on effective interviewing for investigations and information gathering, also known as the mandate principles. As we see indeed both documents as very important instruments that are mutually reinforcing human rights and that also reinforce the unique role that lawyers play in that regard. So thank you so much.
Thank you very much for Valentina. I think we come now to an end. We've exceeded a little bit the time, but it was such a powerful and important discussion to have. I see, Alejandro, that you've put your email address in the chat. So for those people who want to reach out to you directly, You have his email address, alejandro.lanz@temblores.org. I think Clément's email is also on his profile, and you can reach his assistant, and same goes for Dennis. So feel free to reach out to our panelists afterwards. I'd like now to take the time to thank each of you for this very powerful and enlightening discussion. As a lawyer, I'm not confronted with the same level of tension and well, disruption in society as some of you have encountered, but I have to say it has been a call for me to hear from you and to also read you your important guidance, Clément, because it shows once again that it's not something far away, it's really close to each of us where we can act. We can act within our bar association to make things better where we live, but we can also act in solidarity with all our many colleagues who really are pushing the boundaries and risking their lives to try to fight for justice and access to justice for others. So I'd like to thank you from the bottom of my heart and for the discussion, but also for all the inspiration. Your courage has brought a lot of positive energy to try to bring on the fight and keep it and try to make hopefully this year a year where we have positive development and not only sad news. So thank you very much, Dennis, Alejandro, Clément, and all our former panelists and keynotes. And thank you also for the organizers and for all the participants to this very important discussion. Thank you and bye-bye.